Great. Hello, everybody. Thanks, Anna. My name is Yvette Butler, and I'm the Director of Capacity Building and Systems Change with the Center for Survivor Agency and Justice. And I'm joined by Sarah Wee, my colleague, who's our Director of Research and Programs with CSAJ. Thanks, everybody, for joining us for part one of addressing court-related barriers to survivors' economic security. If you could all please go ahead and introduce yourselves in the chat box, that would be great. So for those of you who are unfamiliar with CSAJ, we promote advocacy approaches to remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. And we envision a world where all people have equal access to physical safety, economic security, and human dignity. Now I will turn it over to Sarah. First, our faculty today, we have Nida, Abbasi, Manager for Gender and Family Justice with the Center for Court Innovation, and Jenna Smith, the Project Coordinator with Gender and Family Justice, Center for Court Innovation. And now I'll turn it over to Sarah Wee to give you all a little introduction on the guidebook.
Thanks so much, Yvette, and thanks, Jenna and Nida, for being with us, and for everyone introducing yourselves. Wow, we've got folks from all over the place. It's rolling in so fast I can hardly see. Keep it coming. We are thrilled for this webinar, and I just wanted to give some framing because if you've joined past webinar series, what CSAJ is really focused on right now is implementing and hearing from you all work from our guidebook on consumer and economic civil legal advocacy for survivors, and really engaged in these multi-level webinars that are focused on individual advocacy, as well as thinking about partnerships and community and systems change. So I just want to talk a little bit about our past partnership with the Center for Court Innovation, their work on the guidebook, and how they're going to kind of breathe some fresh and new life into that during the webinar today. So as you can see, this is the guidebook, and it covers a range of really critical consumer and economic needs that you all know survivors face, and we look forward to kind of working through some of those with you. And Jenna and I are going to be touching on some important aspects. So to just highlight a few, first, we really try to ground this work in survivor stories. And an important question for us is always, how do these issues show up or manifest in the lives of survivors? And how does it show up in different ways and really uniquely based on survivors' intersecting identities, culturally specific survivors, underserved survivors, survivors of color, immigrant survivors, LGBTQ survivors, really thinking about that really closely and critically. So what Jenna and Nida are going to do today, and what the guidebook does, is share some case scenarios to really ground the content in the stories that you all are steeped in day in and day out. And so we're going to do the same thing today, where they're going to walk you through some of these case scenarios, get your feedback and input, and you'll see this little storybook icon when we're doing that. And you'll see stories throughout the guidebook as well to kind of help make sense of all the consumer and sometimes new content. And then second, we really think about issue spotting and how asking the right questions and full and open questions is important to this work in linking economic security in a broader safety plan and advocacy with survivors. So we really promote this full and open assessment and critical reflection. And so you'll see this magnifying icon show up when we think both of ways that we can open conversation with survivors, as well as some ways that we can reflect on how our programs and organizations are currently engaged in this work to help us identify ways we might shift or change or modify or do some things differently. And then finally, and really importantly, to these webinars is, what do we do? Often strategies and legal remedies particularly in consumer and economic realm might look different to meet survivors' unique safety needs versus the general population that it's often couched in. So we work with our partners at CCI and a lot of other folks such as yourself on the ground to really identify what are some promising and innovative practices that are going on out there, as well as asking you all some framing questions to identify new possibilities and think through how they might apply to where you are and how your organization is doing the work. So we'll be engaged in a lot of that today, as well as the part 2 of this series next week on April 3rd. So make sure to join us for that and look for this light bulb icon and some of those questions and opportunity to dialogue with us all. And on that, it's really critical that we hear from you all. So I'm so excited to hear from everyone from California to Georgia to Washington State to Washington, D.C. We've got folks all over the place. So if you can keep introducing yourselves and even think about sharing some of the what you're seeing as Jenna and Nida go through this. That'll be really helpful. Start sharing your questions now, and we'll make sure to stop and pause and answer them and engage with you all in some discussion. So I think that is it to kind of set us in motion. And I'd love to again introduce Nida and Jenna to introduce themselves and take it away. Thank you so much.
Hi, this is Nida Abbasi. I am, like Sarah said, the manager of the Gender and Family Justice team at the Center for Court Innovation. A lot of our team's work centers around working with courts and communities around the country to enhance their responses to domestic violence and address all sorts of issues that go into those cases. And prior to working here, I was a civil legal aid attorney in Chicago working on DV and family law cases.
Great. So, and I'm Jenna Smith. I'm the project coordinator here at the Center for the Gender and Family Justice team. We're super excited to be leading this webinar today. Thanks to everyone at the Council and to CSAJ for helping get this coordinated, and thanks to you all for joining. I've been working at the Center since 2015, primarily on our Justice for Families grant, where we're training and technical assistance providers through OVW. So like Nina mentioned, we're working a lot around enhancing justice system responses to domestic violence, sexual assault, and teen dating violence and stalking. So with that, let me just advance the slide here. We wanted to touch on some of our learning objectives for today's webinar. So what we're hoping to cover in this hour so that we're all together is identifying court barriers to access and talking about the economic impact that has on survivors, some strategies that you all may be using or other strategies that we've identified as good practices across the country to try and address some of these barriers, and also looking at how communities across the country are creatively thinking about them and addressing them to tackle some system-based changes to make the process of accessing court easier on survivors, to reduce some of those economic impacts, and yeah, we hope that this will be a useful discussion. It seems like we have a really diverse group on, so we hope you're going to be ready to chat and let us know everything that you're using. We really want to share strategies across the group. So there'll be a couple places throughout where we'll be asking for your thoughts, your tips, and polling the group. So hopefully it can be interactive. So when we think about domestic violence and accessing the court system for survivors, conversations are usually centered around physical safety, and economic security isn't always the first focus. But we know that it's having an immediate impact on the survivor. It may be, it's likely driving a lot of their decision making and is having and definitely presenting its own safety concerns. So when we're talking today about these issues, we're going to be taking a very survivor-centered and holistic approach and using that lens as we think through some advocacy, some legal strategies, and some system-based changes. So some of you have already chatted this in, but we still just wanted to poll the group and get a sense for the types of professions represented on the webinar today. So we have a couple options there. If you don't see your profession listed, feel free to chat it in if you haven't already. We can share those results. So it looks like we have majority of you are advocates. We have some lawyers on the call as well. We have a fair amount of others, and I see those responses coming in. So therapists, social workers, policy, training directors. Great. Some folks focused around housing, other economic issues. Awesome. So definitely chime in throughout and let us know your perspective on some of the things we'll be discussing.
So compared to a lot of other topics related to economic security and empowerment of survivors of domestic violence, a lot of times court-related barriers are less apparent and less defined. So they usually intersect with a lot of different issues that are undermining the economic security of survivors. For example, if a survivor is having issues with job security or job advancement, having to come to court over and over and sometimes spend their entire day in court is only going to compound those issues. Also, moreover, when even though filing for orders of protection are supposed to be free under VAWA and hopefully are across the country, there are oftentimes a lot of other costs associated with just entering the legal process and going through it that we're not always aware of, or we might just ignore because they seem so low, but that can create a huge impact on whether or not a survivor continues with their case or the decisions they make. And court can also be an opportunity for the abusive partner to continue the abuse by being in close proximity with the survivor and even through litigation abuse, which we will discuss further. And finally, existing financial barriers may prevent survivors from even getting to court or continue coming to court to get the relief that they need. So we want you to spend 1 to 2 minutes thinking about this question, which is, what are some economic barriers you see for survivors accessing the court system? We were trying to animate the slide to hide some of those answers, but you can see them, obviously. But if you have more things to add, or if you just want to reiterate some of the things that you see in your work that are already listed there, it'll help give us an idea of some of the priority areas and types of things you're seeing and hearing about in your work. So we'll just give you about a minute to respond and then go over some of the things we see.
While folks are typing, I wanted to share some of the things that showed up in the registration responses that you all shared. So just quickly, some of the common barriers, we're really looking at disparate treatment and remedies for particular populations, and specific immigrant survivors, survivors with disabilities, minority survivors, examining how court actors are treating economic issues. That includes judges, other court officials, the police, how decisions are enforced, other court mandates and programs and their impact, looking at the access to legal representation, both in terms of cost and the types of cases that survivors can get assistance with, looking at general access issues, so court schedules and administration, transportation, time, all of that, and then just how survivors and advocates and programs can become aware of financial resources in your communities, along with a bunch of other barriers, but those are some of the top ones that you all shared in those reports.
Great. So thank you, Sarah, and a lot of the things that a lot of you mentioned and are typing about right now, hopefully we touch upon throughout the webinar, and a lot of them are interrelated as well. So some of the solutions that we offer will hopefully hit multiple of these problems. So one of the biggest impediments for survivors in domestic violence cases, or who are just experiencing domestic violence and involved in other types of cases, is the lack of legal representation. And being a self-represented litigant can also generate a lot of unforeseen economic barriers. So to illustrate, the Self-Represented Litigation Network, or Litigant Network, estimates that 75% of litigants in civil cases are self-represented, don't have access, or can't afford an attorney, and oftentimes that figure is even higher for domestic violence cases. If survivors have multiple cases going on and can't get legal aid on any of them, they're often unable to afford private attorneys on their other matters, especially with family law. And many communities don't have established pro bono programs for domestic violence and or family law cases, and may not even have a legal aid program, which leaves few options for a lot of survivors who are trying to access the court system. And there's research out there that states what we all know, that litigants in family law and DV cases are more successful if they have attorneys. And without an attorney, survivors can face inefficiencies with case processing, prolonged litigation, and scheduling that's completely inconvenient to them and their work schedules, which can in turn impact job security and lead to confusion about financial matters, especially things like child and spousal support that can be really complicated even for experienced attorneys, let alone survivors who are coming to court who likely have no background in the law. And also in terms of safety, not only does not having an attorney create a barrier towards achieving legal relief for survivors, but it also makes them more vulnerable to litigation abuse, which again we're going to discuss shortly. Another barrier involves just the logistical cost of going to court. These costs are largely dependent on each individual survivor's circumstances. So many times survivors have to take off work to come to court and end up there all day. I know when I was practicing, people would have to come into court in the morning and fill out their paperwork and submit it to the clerk's office and then come back at like 2 p.m. to actually go in front of the judge, which is completely inconvenient for most people who are coming, and they end up having to take the whole day off work. They usually have no idea how long the process will be and what it will involve as they're going to court, and having to take off time from work is not only detrimental to a survivor's job stability, but it can also compromise the job of the abusive partner, which can undermine their ability to pay any kind of support. And this can be especially problematic for people who are working on hourly wages, or people who have multiple cases at one time and have to keep coming back to court over and over and over. And court can also take up sick days and vacation days, which can detrimentally impact survivors if they get their paid time off paid out, or if they need to use it for other personal matters, especially if it's related to the domestic violence case, like if they have to move or take care of other personal issues. And also, of course, people need to have time off in order to be productive at work. And getting to and from the courthouse can be very different depending on the geographic location, resources available to the survivor when it comes to logistical concerns. So in rural and non-urban settings, public transportation can be limited and it costs money, and the survivor may or may not have access to a car or gas money or parking money. They may have kids who are involved, and they might not have anyone who can take care of them while they're at court. You have to ask whether the survivor can afford child care, or if there's someone who can watch them for free. And some courts offer child care or allow you to bring your children, but a lot of times survivors don't want to bring their kids to court, or there's other issues with bringing the kids to court if the abusive partner is there, if there are other family members there as well. Another issue that's often overlooked in the court is the potential for litigation abuse. As many of you know, survivors are often in the most danger when they leave an abusive relationship because the abusive partner is experiencing a loss of control. And court may be one of the only ways they're still interacting regularly with the survivor, and they may view it as an opportunity to continue their general domestic violence as well as financial abuse. So abusive partners often control the finances to begin with and therefore have more access to resources like a private attorney. They could be spending their money on private attorneys, which can minimize support orders and spend down their shared assets with the survivor. Private attorneys can also demand burdensome discovery and run down the finances of the survivor by just repeatedly sending motions and forcing them to come into court. Other examples include hiding assets and income to minimize support orders, harassing the victim through frivolous motions like contempt motions, or challenging custody orders or over and over again, which prolongs court dates, which in turn can compromise, again, the survivor's employment as well as the overall legal process. Survivors may even have multiple cases in multiple courthouses and have expressed in different types of research that going to court that much can become almost like another job, and it may pressure survivors to give in early and not get the financial relief that they deserve. As far as litigation abuse goes, the abusive partner may also try to portray the survivor as an unfit parent by filing false reports to Child Protective Services or claiming addiction or claiming that the survivor is abusive partner. And they are usually doing this to try to get custody, and in turn, if they do get custody, they can even get child support from the survivor, which is of course financially debilitating for survivors as well as having a negative emotional and mental health impact on them. Abusive partners may not comply with court orders, which can further deplete the survivor's time and money to try to get the abuser to comply. They might file a countersuit or just continue threatening to file a countersuit. And all the repeat court appearances can take an emotional toll on the survivor, which also can compromise decision-making and their capacity to perform well at work. So as you've probably noticed, a lot of the issues around economic security overlap and exacerbate one another, which can cause them to magnify over time through this ripple effect. So once an individual already faces economic abuse or poverty, it makes them more economically vulnerable. So of course we need to think about ways to break that cycle.
Great. So we have a scenario here that we'd like to read through to bring to life some of these issues and some of the economic barriers that you all have started to identify and things you see in your day-to-day work. So as we read through it, we'd like you to just think about, flag any sort of economic related issues that our survivor here, Alex, is or might be experiencing. So Alex comes to court at 9:15 a.m. seeking a temporary order of protection after her partner threatened her in front of their 2-year-old child. She's directed to the clerk's office and is given a form to fill out. Alex fills out the form alone and brings it back to the clerk, who tells her to return at 2 p.m. when the judge will hear her petition. Do you see any issues that may impact Alex's economic security? We'll give you a minute to raise those. You can put them into the chat box. Great. So I'm seeing lots of good issues being identified. Right, and one raising that needing to come back, and that time she may change her mind. She's already experiencing quite a few barriers in having to go to the courthouse, needing to presumably arrange for some kind of child care, which may have an associated cost, or she's relying on a friend or family to watch the child. We don't know if she has a job, but probably she may have needed to take off of work, gotten permission for that, or maybe even just missing a day and that not looking great to her employer. And then transportation issues. So like Nida was talking about before, whether or not there's public transportation, does she have a car? I saw someone chat earlier in the chat box that in their community there isn't really access to Uber or Lyft, and if there isn't public transportation and someone doesn't have a car, how are they getting to the courthouse? Again, are they relying on friends or family, or kind of exhausting those other resources to get to where they need to go? And she's going to have to return, so is she needing to buy lunch? Is she needing to buy food as she's spending her day at the court? So we'll continue with this scenario. So now Alex leaves and returns at 1:45 p.m. just to be safe. She ends up waiting until 3:40 p.m. when the judge calls her case. The judge grants Alex the order within a few minutes without any child support and tells her to return in 3 weeks. When Alex returns, she finds out her partner was not served yet, so the temporary order is extended for another 3 weeks. So again, what issues are you seeing now that we've learned a little more about Alex? How is this impacting her economic security? Great, so you're all raising some really key issues, right? She's already been to the court now twice, so that's 2 days she's devoted, and in those 3 weeks, she hasn't gotten access to any financial relief. There's no child support on the order that the judge issues. It's being postponed for another 3 weeks. A lot of you were chatting earlier about issues with serving abusive partners in your community and associated costs that you're seeing survivors experience with that. And so again, she's she's having to arrange for child care, she's taking time off work. She may not have anticipated this taking this long in the first place. So these barriers may be, again, affecting her decision making as she's struggling financially and having to deal with all these associated logistical costs. It seems like the partner is evading service, so there's that potential for using the system to further abuse. And we don't know her housing situation, so where is she living? Can she pay her rent? All these types of things are being exacerbated as she's trying to get access to protection and support. And then there's even just the emotional costs. With it taking this long, having to share her story, personal information, all of these intimate details with the court system, and the judge is only spending a couple of minutes with her. So at this point, she may be rethinking whether this is the right way to address some of these issues. So Alex returns to court once again with her daughter since the daycare was closed. She connected with the domestic violence agency the previous week, and her advocate is also in court with her. Alex's partner has hired a private attorney who asked to extend the date so he can gather evidence prior to the hearing. The judge tells Alex to gather any evidence she has for the next court date, and she nods in agreement. So what other issues now are coming up? Any other ones that we haven't now addressed already? And as you're chatting those, also feel free to mention any ways that your community might be addressing these. I saw someone shared earlier in Las Vegas, I think it was, about their partnership with legal aid and helping survivors get access to representation. Right, so we have the power imbalance already in this relationship where Alex is a victim basically to her partner's abuse, and that power imbalance is now being exacerbated by the fact that he's coming with private representation and she does not have a lawyer with her. And I think earlier someone mentioned about court and judicial perception of credibility. So she's showing up to court without a lawyer. She's showing up with her daughter because she can't find childcare. So how is the judge now perceiving Alex? And her abusive partner is showing up with an attorney. He may be in a suit, and so he may be appearing to the court to be the more credible person in this case. She is connected with an advocate, so that advocate is going to be helping walk her through the process and hopefully giving her some additional information about collecting evidence. But again, we have the time delay. She's going to need to track that down. She may have to go and retrieve police reports. So this is additional time and potential economic costs as well as emotional costs. She's probably still having to take off work, and her employer may be losing patience perhaps with her having to keep going to court. It's probably affecting her job performance as she's experiencing the stress of leaving this relationship and having to deal with all of these court processes. And some additional facts just to share about Alex. The case continues for the next 6 months. She lives an hour from the courthouse and drives a 20-year-old car. She works as a waitress at a small restaurant. She was in the process of taking courses to get a technical certificate, but put her classes on hold so she could pick up extra shifts and pay for babysitting and rent. Opposing counsel has sent about a dozen motions to Alex, none of which she understands. And Alex's ex-partner does not pay any support, often misses visitation with their daughter, and skips better intervention classes due to the cost. So with these additional facts, we learn a little more about Alex, about her, how she's paying all these costs, her work, she's having to take off time. She does have a car, but she's putting a lot of miles on it. It's an older car, and now she's contributing to the wear and tear of the vehicle. We're seeing additional child care issues, litigation abuse from the opposing counsel who's filing lots of motions, and Alex doesn't have legal support to help deal with those. And then we also see that the abusive partner, right, he's not paying child support or going to visitation, and he's also skipping those better intervention program classes, which have an associated cost. So a lot of places offer sliding scales, but even $5 a class can be cost prohibitive. And so right now he's not really receiving any measure of accountability either through the court system or through these classes. And 6 months have elapsed. So with all of that, all of these barriers that we've seen related to economic costs, we know that this is a driving reason that survivors end up returning to abusive relationships, is particularly around finances and logistical costs. So we wanted to use this scenario to just highlight those.
So this, again, was supposed to be animated so that you saw the little bullets later. But we wanted to ask, when survivors are going to court, what do you see in your work as their biggest concerns, or what do you think are some of their biggest concerns that they voice to you, especially if you work directly with survivors? Because a lot of the things that they mention might not directly center around economic issues, but more likely than not, they are going to be tied to their economic security. So some of the things that we've seen in our work are safety risks that are posed by the abusive partner or ex-partner. They're just not sure if they're going to be separated from them at court, or if they're going to have to interact with them. They might just be scared to even be in the same vicinity as them. How that person is going to react to court involvement. A lot of times survivors are hesitant to even get involved in the justice system because they're worried about escalating the abuse and the abusive partner becoming angry that they're having contact with law enforcement or with a judge because of actions taken on behalf of the survivor. They're also worried about how the court will respond. I know when I was practicing, there was a huge discrepancy between what survivors thought was going to happen when they came to court and what actually ended up happening. And at the end of the day, when they're going through a domestic violence case, you get a piece of paper, right? And it doesn't seem like a lot of protection. So just having to walk survivors through that process and taking the time to explain the actual legal process is really complex, and it can be overwhelming if they don't have anyone to even do that for them. And then also any potential negative consequences of exposure to the justice system. So again, a reason why many individuals don't want to access the justice system at all is because they might have like a community, like a historical community negative view of the justice system, or they may have had negative experiences with the justice system, or they might have heard things and they just don't want to get involved at all. So why are some of these general concerns important to the issue of economic security? Economic barriers can also compromise victim autonomy and their ability to achieve safety. Economic instability can pressure survivors into making unfair choices or returning to an abusive relationship. I know that a few of you mentioned in the chat box comments about survivors feeling like they have to return to abusive relationships, and it's definitely one of the #1 reasons why survivors stay in abusive relationships or go back to them, because they are unable to feel like they can achieve economic stability on their own. Financial dependence on abusive partners can impact their long-term safety and ability to survive on their own. And if survivors are not able to get support orders easily and early, or face a prolonged court process that ignores some of the behind-the-scenes financial issues that are going on, they might not view court as a viable option. So by addressing these issues, the court and community can facilitate greater confidence in the legal system, and more effective case processing through shorter cases and court dates and orders that include support will lead to greater trust in the legal system, as well as increased safety. And it's important to implement a victim-centered approach whenever possible by recognizing all the issues victims may face outside of what's presented in court. We can hear the victim's view of their situation and promote their autonomy and assessment of their safety and needs. And we like to say that generally a victim has the best evaluation or assessment of what their safety needs are, so we should really prioritize their view on those things. And it's also important to recognize the additional access to justice barriers that exist for victims who are immigrants, justice involved, or represent various identities. So these groups of survivors and others may have additional issues that impact their economic security throughout the legal process, especially if they're hesitant or reluctant to even come to court to attain legal relief. So immigrant survivors may be facing immigration abuse, whether they are documented or not, and their abusive partner could be holding onto their paperwork or manipulating their ability to seek employment or other services. Of course, there are several reasons why they may be avoiding contact with the legal and justice systems, which could compromise their ability to get the support and the relief that they need. Survivors with limited English proficiency really need translation and interpretation services to partake in the legal process, even if sometimes they may not admit to needing interpretation. If you think that there's some sort of language barrier there just for the sake of access to justice and because the legal process is so complicated and difficult to understand, the best practice is to make sure that they have the language services that they need. However, that's not always available to them. And survivors with disabilities may find the actual courthouse difficult to navigate. There might be poor accessibility, poor signage, etc. And they're also generally more vulnerable to abuse, as well as survivors who are part of the LGBTQ community who may find the protection order process challenging due to gender norms and stereotypes, as well as skepticism by some of the justice system actors that they may encounter through the process. And finally, survivors who belong to communities of color or who are previously or currently involved in the justice system are other groups that may feel unwilling or hesitant to enter the legal process to begin with, like I said, either due to historical issues with the courts or previous contact or things that they've heard through their communities. So when thinking about ways to remedy these issues, we have to be cognizant of the identities of people using the court system and how to respond to their needs. So we want to think about problem solving with a survivor-centered lens, and we're going to touch upon some individual and organizational approaches to that. So if you're seeing many of these issues in your community and hoping to implement ways to facilitate greater economic security and reduce court-based barriers for survivors, an important first step is assessing how your local system works around the court and around the community. So these are just some reflection questions to think about. What is your agency's relationship with the local court? A lot of you are advocates and attorneys, and I know sometimes it's hard to build relationships between your organizations and the court and get a coordinated community response and larger buy-in. So thinking about what that relationship has been like historically and what gaps currently exist that could be addressed. Thinking about whether there are judges with whom you have a positive relationship that you could maybe leverage to get a better relationship moving forward. Also, how do you collaborate with the court? How do you collaborate to learn what challenges they face and work with them to problem solve around these challenges? Based on a lot of the judicial and court staff training we've done around domestic violence, there are a lot of gaps in knowledge and expertise around what's going on with domestic violence survivors and abusive partners and why those dynamics are so unique compared to other types of cases. So there's definitely a lot of work that can be done in terms of education and problem solving. Also, do you participate in stakeholder meetings, if they have them in your community, to discuss policies and procedures and communicate with other agencies in the field, such as abusive partner intervention programs, culturally specific organizations, which are extremely important, or supervised visitation providers. If you don't have current stakeholder meetings, are there ways that you can conduct outreach and try to get people on board and facilitate more information sharing between different agencies that are having contact with these cases? And also, what kind of training on domestic violence has the court and other agencies received? Do you have shared language? Is everyone thinking about domestic violence in the same way? Are there gaps you can bridge? Have you asked the court in what areas they need further training, and could you provide it?
So we have a couple poll questions that we wanted to ask you all. This is just one example of a common economic issue that we see related to getting child support, particularly on temporary orders of protection. So if you could take a minute and respond. We want to know if you have statutory authority in your community for petitioners to request child support in temporary orders of protection. It looks like more than half of you say yes, and about 20% say on occasion, and then another 30 or so or no and never. And then we have another question related to that. For those of you who, where it is a remedy. So if it is a possible remedy on the temporary or ex parte order, how often is child support requested? Almost always, sometimes, rarely, never, or I don't know. Looks like a fairly even split. Rarely is kind of the highest right now. Yeah, a fairly even split between almost always, sometimes, and rarely, which is interesting. For those of you who are saying rarely, if you want to chat in why you think it's not often requested, that would be great. And then we can move to our third question. And then for when it is requested, how likely are judges to grant it? So likely, sometimes, unlikely, I'm not sure. Someone's saying in North Carolina that judges are less likely to grant it, they're hesitant to. Seeing a fair amount of sometimes, about 30% sometimes, 30 unlikely, and then some yeses, some I don't knows. So this is an illustration of just one common economic barrier that we see, but it's the type of thing that you can kind of track in your community, see what those main issues are, look at whether, our advocates, survivors, and attorneys, are they asking for financial support? Is the issue that it's not being asked for enough? Is the issue that judges aren't granting it? Is it a combination? What kinds of training can you maybe offer within your agencies about making sure to address those economic issues when you're filing, and then even offering training to judicial and court staff around this issue, around the statutory authority that exists in your community, and reasons why they would want to grant it. And then we have some resources at the end that we're going to share, but our team here is actually working on a toolkit specifically on the issue of child support in domestic violence cases, and should be released in the next few months, so stay tuned for that resource, but you can definitely look for it on our website when it's out. I skipped one, hold on. So some approaches, right, to obtaining child relief on temporary and permanent orders, and making sure that you're exhausting all of the possible economic options available to survivors. So looking at other types of support under VAWA, whether it's spousal support, looking at compensation for damages, which quite a few people raised that in the chat box as issues they were seeing, not getting restitution. And in terms of ensuring payment of support, we wanted to highlight one program here in New York City, in Brooklyn, where there's a parent support program that for those non-custodial parents who are low income and maybe don't have employment but have really high child support obligations, linking them to employment, to job skills, as well as parenting classes, and using that as a way to ensure payment for child support that they can afford, and also still having that accountability measure in place around giving money to support their kids. And then in the scenario earlier with Alex, we flagged that the abusive partner wasn't going to those better intervention programs because of the cost, and we work with one community in DeKalb, Georgia, where they saw that that was a frequent issue, that the better intervention program costs were too expensive for offenders to go, and not wanting to sort of let that be an out, but wanting to also recognize that if they couldn't afford them, that continuing to charge the fees was not going to help. They started a workforce development program with regular compliance reviews. So the offenders get linked to job searches and resume building and linkages to employment, and then that once they start getting work and start getting paid, those costs start going towards paying towards those better intervention classes. And then the court is regularly monitoring and using compliance reviews as a tool to make sure that they're attending and complying with the terms of the order.
So courts can be a place to also refer survivors to additional services that can help them get more control over their lives. And court can have brochures or help desks that can offer a variety of services, including financial resources like career advancement or job training that we were just mentioning. And I know a lot of courts don't have these help desks, or they might have them without all those resources available, but if there's an option to maybe start a communication with the court and discuss those issues, that's definitely a good service to have. And while order protections should be free to file, courts can also think about waiving fees for other types of filings, and even for little things like making copies or somehow the small costs associated with the classes that are ordered or treatment programs, which again may not seem like a huge amount of money to some of the other people who are working in the courts, or some of us who are working with these clients, but it can make a huge impact for survivors and the abusive partners who are deciding whether to take them. And in New York City, we have an organization called Sanctuary for Families, which is a legal aid and advocacy organization for survivors of gender-based violence. And they developed a program for career development for survivors, and the courts can refer litigants in domestic violence cases to that program, and they can engage in all sorts of job readiness strategies and classes, and they'll be pushed towards greater financial stability, and they've had a lot of success around that program. So if you work at a legal aid or advocacy organization, that's definitely something to think about, starting an initiative that targets job readiness for survivors. And if you want more information on that, we have resources towards the end, and we're happy to connect anyone to SFS. And also, it's important to think about ways to train court staff on the resources that are available, because a lot of times they're not aware of a lot of culturally specific resources or other things that survivors can use to achieve greater economic stability. And what are ways the courts can better manage the legal process to reduce some of the economic barriers that exist? So there are a lot of resources out there on litigation abuse that target judges and court staff and things they should know. So sharing those resources and bringing up those issues before court actors is an important step in intervening and preventing that type of abuse. It's also important for judges and court staff to actually be able to recognize litigation abuse and intervene. Judges can look for the signs that we described earlier and make sure that abusive partners know they can't manipulate the legal system. So some of the ways they can do that is having one judicial officer oversee all the litigation in a family, which keeps all the information centralized and maintains a full picture of the case and all the behaviors that are going into it. And we'll talk a little bit more about different models that can accomplish that. Also, judges can impose actual real-life consequences rather than just verbal admonishments, which include sanctions and attorney fee awards. Even if the survivor is self-represented, of course they're still taking time out of their day to represent themselves. So I know that it's uncommon for judges to do that, but that's definitely something we can try to advocate for. Judges can also prohibit or limit abusive litigants from filing new motions. They can require that abusive partners complete treatment or classes prior to filing any new motions, or implement a review process that does not force the survivor to come to court and just has the judge evaluate the motion for merit before proceeding. And of course, judicial and court staff training is essential. We've mentioned this a few times, as well as training for people who are serving the survivor and abusive partners in order to help them recognize some of the signs of litigation abuse when it's happening. Also, the issue of time management, trying to prevent survivors from, we can implement different ways to try to prevent survivors from spending their entire day in court, like informing survivors beforehand on whether they need to come to court and what the day is going to look like. Also avoiding multiple court dates through more effective scheduling. One of the things that we get asked about a lot is litigant satisfaction surveys and ways to measure how litigants feel about the court process and their experience. And that's helpful in addressing any ongoing issues that happen across the board and assessing any gaps that are happening specifically in your community. And legal representation can not only help the survivor obtain financial as well as other types of relief, but it also helps them avoid contact with the abusive partner and contributes to their safety. So we want to know, how might economic hardships be addressed more on a system level throughout the court system and throughout the community. So just take another minute to think about this issue more from a macro systems level, and anything you can think of that could try to facilitate change from that perspective. Okay, so someone said educate workplaces on the importance of having policies in place to address time off for court. So that's a great idea, because I know a lot of survivors are reluctant to continuously ask for time off court, as well as abusive partners. So if workplaces were more aware of the legal process and what it involves, they might be able to be more flexible. Waive litigants' appearances in some cases, especially if there hasn't been service yet. Illinois has a state law that requires employers to give time off for DV. So yeah, affecting change in the entire court and community's response to domestic violence is definitely a long-term process and requires a lot of different steps. And one of the things that we try to promote the most is a coordinated community response, which would involve all the different stakeholders from your community who touch a domestic violence case, coming together and being able to share best practices and just getting everyone on the same page and communicating their issues openly, which facilitates greater buy-in and just generally an enhanced response to DV in the community from a systems level.
And so to affect some of those more system-based changes, we've talked a little bit about finding your key champion. It's not easy to do, but if you find a judge or even a court administrator or someone within the system who has some additional power and weight that is either educated on DV dynamics, is interested in learning more, open to making the process easier, and looking at it as an access to justice issue, that person can be really effective in helping kind of corral stakeholders and bringing them to the table. When a judge calls a meeting, it definitely means a lot more, and even just looking at who, for any meetings that may already be happening within the community, looking at who's at the table and who might be missing. So making sure all of the players are represented, including culturally responsive organizations and services there, including others within the system, are really key, because what can happen is people can be relatively siloed, and you may all be seeing the same issues across disciplines, but having an opportunity for people to share and raise and educate one another about what they're working on is really crucial. And then through convening regular stakeholder meetings, even establishing a working group perhaps on economic issues, or tracking different data around financial relief being issued, or looking at what the biggest economic costs and barriers are for survivors in your community, and pulling together some information and maybe raising it to others, maybe just picking one issue that you think is the most immediate and important, and strategizing around possible solutions or partnerships that could help address it. Even just through things like we've talked about on-site services and access to pro bono representation can really make a big difference. We also just wanted to highlight the ways in which specialized courts around domestic violence can be a helpful tool. So in New York City, they use an integrated domestic violence court model, which is a one family, one judge. And that helps reduce the number of times that victims are appearing in court. It also helps coordinate between the civil and the criminal side, so reducing the likelihood of conflicting orders, you're streamlining cases. And the real advantage to a specialized court approach is that everyone is trained on the issue. So from the judge to the court security staff in the room to clerks, all of them have DV training and have a dedicated approach. And then again, linkages to advocates, to pro bono representation can really be strategies for this. And other jurisdictions who've implemented specialized dockets, not everyone uses an integrated approach. Some have specialized civil domestic violence courts, some have specialized criminal approaches, and they hear different types of cases. And there's a few places that use a coordinated model where maybe there's a dedicated family court judge and a dedicated criminal judge, but there's information sharing across both sides so that you're not getting those conflicting orders. And again, court-based resources, so co-locating services, reducing the number of times that a survivor has to go to various places and access those services, having things located on site, and even using technology, so expanding opportunities for remote access through e-filing. We've seen a lot of jurisdictions working on projects around that, and federal grants can be another way to tackle this issue. OVW has a lot of grant funding streams where you can get the court on board, apply, and use money to send judges to training around DV. You can dedicate your grant project to setting up a specialized court, or maybe assessing the needs of your community specifically around financial issues, and using that grant funding as a way to build additional partnerships and tackle these issues. So you've all have been really chatty in the chat box, which is awesome.
Keep track of what you're saying. I was trying to read some of the comments, and then somebody else would write something and it would disappear. So I didn't see everything you guys wrote, but I feel like you shared so many promising practices that we could incorporate that into our work. There was so much stuff out there.
So you feel free to type in additional questions or continue sharing across jurisdictions. There's been some really, same as Nida, I've been trying to track them as we go through, and they've been flying by, but it sounds like there's a really great discussion going, and some awesome strategies in place.
Yeah, so there was one question just a bit earlier about the one family, one judge, and how that works, and just clarifying, like, is it the same judge that handles like criminal, divorce, custody, everything for the same family?
Yeah, so the way it works in New York City is any criminal case that involves domestic violence, if there's a custody or divorce or visitation-related civil hearing is heard by that same dedicated integrated domestic violence court judge. So yeah, so the judge hears both the criminal and the civil cases. The cases stay separate, so there's still a separate criminal proceeding and a separate family court one, but the idea being that the judge has more access to the information, understands the dynamics within the family, and is issuing orders based on that knowledge.
And there's a few other courts around the country who use something called a coordinated court model, specifically Winnebago County in Illinois, where they have different judges hearing the criminal case and the family law / DV civil cases, but they share the information between the judges through a resource coordinator, so everyone knows what's going on in the case, and it prevents things from falling through the cracks. So that's also one way you can avoid any type of litigation abuse as well. Sarah and Yvette, did you notice any other questions pop up in the chat box that we could maybe help answer?
Yeah, this isn't so much a question, but I noticed kind of this issue that somebody presented that seems like it'll kind of segue into what we're talking about next week, but if you have thoughts or know of folks who have similar experiences. Someone talked about actually the challenge in partnering with court systems, and that they actually have a great relationship with a few of the counties they cover, but sometimes those relationships can create a new obstacle in the sense that survivors see our closeness and can struggle to see us as trustworthy. And then they also assume that we might have more pull at that office or that system than we actually do. So do you have any thoughts based on all the communities you work with about how folks have kind of grappled with the that partnership building, or might kind of both build that relationship while still holding those systems accountable? Or just curious of your thoughts there.
Yeah, that's definitely an issue that comes up a lot if it's a project that's not led by the court. We get asked how to get the court on board, and there's not really one simple answer. One of the ways that a lot of communities do that is, I think we mentioned, if there is at least one judge who seems open to getting training on domestic violence and learning more about DV dynamics and different things that go into those cases, and building a relationship, just starting off with one judge or one court administrator, someone who's a leader in the court, then it helps to trickle down and get everyone else on board, because I know, as a lot of you who work in the court system probably know, if the judge is on board, it's easier to get everyone in the court system and get their colleagues involved as well. So trying to target someone who could potentially be interested in implementing some of these strategies is one way to start building that relationship, just starting small and presenting some of the issues that you've been seeing over and over again. Another thing that comes up is concerns around neutrality, because judges oftentimes don't want to feel like they are being specifically survivor-centered, because it feels like they're leaning too much towards one side in a DV case. So sometimes we approach the issue as something that facilitates greater safety for the family overall and greater accountability towards actually following the orders, instead of branding it as survivor-centered. Or sometimes we'll bring up the issues around the impact on children, and that can get people interested in the issue. So you have to be strategic around ways to actually get people to listen to you sometimes.
Yeah, and I think just to tag on to that, another way to frame it, particularly in getting judicial and court involvement, is as an access to justice issue. So a lot of, we focused a lot on the economic barriers posed to survivors, although also address some that abusive partners face in attending FIPS and other things. But if you're improving outcomes for survivors in terms of accessing the court system, you tend to also be reducing access to justice issues across the board. So framing it through that lens can be helpful in getting court and judicial involvement. We also talk a lot about procedural justice. There's a lot of research around when litigants feel that they've been treated fairly and respectfully by a court process, they're more likely to comply with orders. So that can be another angle to take, and is a training that we and other national TA providers offer.
There was also some discussion early on about process servers, and I know like some people had mentioned issues with maybe them being very costly. Do you two have any suggestions to like tackling maybe like process server costs? Like, is there any way around that or to help with that issue?
Do you mean people having to pay to get the order served on the respondent?
Right.
I have never seen that before or heard of that.
Or maybe, or like, maybe people.
Yeah.
Or maybe people in the chat, if they have like a specific issue with that. But I know that there was a big topic of discussion very early on.
Okay. I'm not sure, because at least when I was practicing, I didn't see the judge or the court requiring the survivor to pay anything related to the filing of a DV case or getting it served. I know that comes up in non-DV cases, but that is probably also an issue that needs to be addressed with the courts, and developing policies and procedures around domestic violence and economic security of survivors, and trying to avoid different types of costs that might be associated with those cases. Okay. But yeah, sorry, we have limited knowledge of the costs associated with any type of private service. but we can try to look into that and maybe see if there are resources.
Yeah. And if folks who mentioned that either in the evaluation afterwards or even now in the chat want to share a little bit more context, we can also follow up with you to kind of learn more and see if there's ways we can dig into that together.
Charlie also highlighted a great framing for, building that relationship building with the court is that if you're framing it as increasing efficiency, that often really speaks to judges and courts that if, the processes are simpler, there's more access to information at the beginning, you're reducing having people have to return multiple times or refile. So that can be another way to kind of approach it.
Mm-hmm.
Okay, great. Any other questions?
Okay, so we wanted to share some resources that we thought might be helpful if you want to think more on this topic. So they're all linked here. I'm not sure if you can click them through Adobe, but we can share them later on as well. But one is Financial Insecurity and Domestic Violence, a conversation about child support, which is of course, specifically targeting how child support works in domestic violence cases and how it can contribute towards survivors gaining more stability or can undermine their financial security. Also, we have something called Assisting Self-Represented Litigants in Domestic Violence Cases, which is all around people who are pro se and can't get legal representation and different strategies to try to help guide them through a DV case so that they understand the process and can represent themselves effectively. There's also the thing I mentioned before about Sanctuary for Families Economic Empowerment Program. I think that is linked to their website, and you can get more information on how they started that program and what kind of impact it's had on survivors throughout New York City and its 5 boroughs. And then NCSC, which is the National Center for State Courts, created this resource called Facilitating Access to Protection Orders, Technology Solutions to Overcome Barriers, and this is useful for domestic violence cases where survivors may not want to be in contact with the abusive partner, or for survivors who live in rural areas and other isolated areas who don't have easy access to the court. And it just talks about different ways you can use technology to continue with a court case, such as through remote resources and video resources. And Jenna mentioned earlier that we have a child support toolkit coming up. So if you have any questions for us or comments, all of our contact information is listed there. And if you just want to look at some of the work we do in other areas, you can go to dvcourts.org, and that is our team's webpage. And we have part 2 coming next week. Sorry, Yvette, go ahead.
No, I was going to say thank you so much because this was really great. But please, I was going to do a plug for part 2, but please feel free to, if you'd like to do your own, please.
No, we just wanted to say thank you to everyone who joined today, and thank you for being so engaged in the chat box. I think this is the chattiest chat box I've seen during a webinar in a long time, so that's awesome.
I can't wait to go back and read everything.
Yeah. So
and someone in the chat actually asked for a transcript, and we can do that, as well as we've been kind of chatting behind the scenes as well about pulling out some of the the key issues and strategies that you all were working on together and sharing that with you, so you don't have to read through a whole 90-minute transcript. So we'll think about some easy and accessible ways to share some of the key key stories and points you all were making.
Yeah, and I think like one of the exciting things about part 2 is going to be that like there's a lot of strategizing together, which everybody was already doing in the chat. So I'm really excited to see all the depth we might be able to get into next week. So Sarah, do you want to take it away with some resources and announcements?
Sure. So as folks are sort of drifting off, just a few kind of housekeeping logistical pieces. We will be sharing the recording, the PowerPoint, as well as links to the resources Jenna and Nida mentioned in a follow-up email. And because we have the part 2 next week, you can expect that in your inboxes probably the following week, so the second week of April. So we will get that to you, and you will receive a direct email when that's all ready to go. And then, of course, feel free to reach out between here and there if you have questions. And if you do have questions, reach out to Jenna and Nida, contact us at info@csaj.org, and we can connect you. We're happy. This is really, for both next week and in general, the start of a conversation, and we're happy to kind of think more in depth with all of you. And so to support that, you all shared a lot of stuff, and we are trying to really capture that and uplift it and share it with the field. So if you are doing innovative work in this space or in a related economic or consumer justice arena, go ahead and click that link and share your work with us so that we can talk with you and learn your strategies, your promising practices, and share that with the field who, share with other folks who might be dealing with similar issues. Some other tools that came up, Jenna and Nida talked a lot about kind of assessing organizations and thinking about court barriers in the context of survivors' holistic economic and varied other needs, and this assessment and strategic partnership tool is a really nice way to kind of start thinking about that and thinking about what our programs are doing or could be doing differently. So I would recommend you take a look at that. Please download the court barriers chapter in the file pod here that we have right now, and also go to our website to take a look at some of these other tools that we've partnered with CCI as well as other advisors and organizations in the past, really to help frame the issue of economic security for survivors, a survivor-centered economic advocacy approach, and learning from pilot sites and other work that has gone on in this space. So these are all valuable tools for you in general and related to court barriers. And so just again, take a look at the guidebook and all the chapters, including the court barriers chapter, and let us know what else you need to support implementing this in your program or organization. I also want to point you to another resource that we have called Accounting for Survivors' Economic Security, which is really seeks to kind of help shift the paradigm of what we mean by economic security and how all of these barriers really interlock and play a role in survivors' lives, so that we're really targeting some of the root causes in that work. And this is a helpful tool in the framing conversation that we just had as well. How can we talk about the issues survivors face when advocating with judges or public benefits or other services and providers that we're partnering with. And then related to meeting the needs of underserved survivors and survivors of color, we held a series of listening sessions a few years ago and showed this report on how we can show up for underserved and marginalized survivors. So I'd recommend taking a look at that, which again kind of helps us think critically about how our organizations are set up and doing this work right now, and how we can better understand and engage and lead from the direction of survivors that we're working with. So I hope you take a look at all of those resources. I hope you let us know what you thought about this webinar and what else would be helpful going forward. And I really hope that if you haven't registered, go back to that link and make sure that you join us next week to really continue a lot of the strategizing and discussion you all started today. I'm really excited to hear from a model that Jenna and Nida work with and more details about some of their court models to really fuel the flames of that discussion next week. So I think that's it, and thank you so very much. I hope you have a good rest of your week.
Thank you.
Thanks. Thanks, everyone.
Thank you.